Impeachment, impeachment, impeachment. That's all we're going to talk about today, okay? Impeachment, weapons of mass destruction. Okay, but here's the thing. We are going to find the weapons of mass destruction, and we're going to learn to use how we're going to learn how to use them, okay? We're going to find the weapons of mass destruction. We're going to learn how to use them. The fact of the matter is, I can think of no area of trial advocacy that lawyers do worse than impeachment. Lawyers have no macroscopic concept of impeachment, and when they get into doing it, they're usually horrible in doing impeachment, and I mean horrible. The California code, the evidence code in California, I was doing a program a couple of years ago out there, and they were talking about impeachment with inconsistent statement, which is, Stephanie, what we're going to be doing all day today. And the lead line in the commentary says, lawyers don't know how to impeach with an inconsistent statement. And I wholeheartedly agree with that. I have seen some miserable jobs. As a matter of fact, I have been a judge for many years at the national competition put on by the ABA Criminal Justice Section and the John Marshall Law School in Chicago. It's a good competition, criminal law competition. And by the way, a good competition that Stetson has excelled in. Stetson's won it several years. Matter of fact, I have a program from this year's that I brought to Charlie Rose that I'm going to give him, which traces the history of the program. But I was a finalist judge for many years. And interestingly, the young women, the young men would come down, and they were well-trained. Maybe not all quite as well-trained as the people from Stetson, but they were well-trained. And, well, Lord knows they should be, because they had tried this case, I think, 5 times before I saw them in the finals, okay? Well, their closing arguments were extraordinary, just extraordinary. Their opening statements, very, very good. But as soon as you put a witness on the stand, i.e. direct examination, the ability of the trial lawyer students went down. They weren't, the directs traditionally are boring, but that's another subject for a different time, okay? And the cross-examinations were, without question, the weakest thing done by the students. Their concept of cross was horrible. But yours should never be again, now that you know how to cross, okay? But anyway, then there was a portion of the cross-examination of impeachment. Usually it was an impeachment with an inconsistent statement. That's the kind that was written into these problems year in and year out. And I tell you true that I've never seen a student, as good as they were, and they were good, properly impeach with an inconsistent statement. They had no earthly idea how to do it. Well, we're going to change all that for you today, okay? I'm going to teach you about inconsistent statement impeachment. The fact of the matter is, most trial lawyers don't know what they cannot do in impeachment. They don't know what they can do when they impeach. And worst of all, they don't know how to do what they can do, okay? So that's what we're going to sort of address. These wonderful weapons of mass destruction. Great, but you got to find them. And you got to learn how to use them, okay? You're in trial. The benevolent judge looks down at you, Stephanie, and says, "Counsel, you may cross-examine." Well, what is that? Kels, that's an invitation. An invitation to do what? An invitation to do three things. There's always three, right? An invitation to do three things. What's the first thing you can do given that invitation? The first thing you could do, of course, is waive the cross-examination. Huh? Your Honor, I have no questions. Is that the way you waive? No. Every lawyer that waives cross-examination, and by the way, there are times, there will be times when, not often by the way, but when it's the proper and right thing to do to waive the cross-examination, okay? But any lawyer waiving the cross-examination, I will tell you, will never just say, Your Honor, no questions. But the big trial lawyers, what they're going to do is waive it with totally gratuitous, totally improper comment, okay? For instance, how do they waive it? Your Honor, this witness didn't hurt us at all. I have no questions, or there's no reason to cross-examine the witness. The witness didn't say anything of importance, so I have no questions. But every lawyer I've ever seen waive a cross-examination does it with some gratuitous, improper comment, okay? And then they proceed to waive it. Now, so that's the first option open to you as a cross-examiner. But that's going to occur very, very seldom. We're not interested in that. The second thing you're invited to do when you're told you may cross-examine, you may go into the subject matter of the direct examination. What was brought out in direct, you may go into. By the way, that is a very liberal standard. In other words, the court, and rightfully so, if the witness comes anywhere close to going into something, you as a cross-examiner will be given the latitude to go into it on cross. The court's judges make a lot of sense when they rule on this, and they use a very liberal interpretation of it, which indeed they did, okay? So what are you going to do here? You're going to maybe challenge what the witness said factually. You're going to clarify it so that it comes out a little closer to where you want to be. And that's what we're talking about when we talk about cross-examination on the basis of the direct examination, okay? And then there is a third thing that you can do when you cross-examine. And the third thing, let me give it to you in the words of the evidence people. Obviously, as you know, I'm not a fan of these words, but this is what they tell us. And this is what the rule speaks of, okay? The rule says, basically, you may go into matters affecting credibility. Matters affecting credibility. That's a mouthful of hogwash. Why? Because credibility, well, we'll talk about that in a moment, that's not quite accurate. But worse than that, we're trial lawyers. We have a word for matters affecting credibility. And our word's a beautiful word. And it's the word that should be used. And what is it? You can impeach the witness. The rule should say you can impeach the witness, counselor, and they would be much more accurate and make a lot more sense than say matters affecting credibility, okay? But that definitely you can go into, okay? Now, let me pause there with that. Matters affecting credibility. If you look it up in Black's Law Dictionary or you read the evidence books, matters affecting credibility suddenly becomes veracity. They like even a bigger word, okay? And so you can go into matters that affect the veracity of the veracity. Oh, come on. We're still talking impeachment. And now I'm going to shock you by telling you that veracity and or credibility are not really, they don't sum up what this thing is all about. Why not? Because, oh sure, some of the things we do when we impeach do go to veracity or credibility, okay? Sure, certainly. And as a matter of fact, I'll agree, most of the things we use to impeach do go to veracity and credibility. But there are other things we do to impeach, as you will soon find out, that don't have a damn thing to do with either veracity or credibility, okay? Well, give us an example, Terry. Sure. We're going to find out in a little while that one of the methods of impeachment, okay? As a matter of fact, my fourth method of impeachment, we'll get into, I'm going to give you a list of these things, but my fourth method of impeachment, and a proper method of impeachment, is impeachment with Federal Rule of Evidence 609. Now, what does that say? That says you're allowed to impeach with a conviction. We're not going to talk about the details of this now. Maybe we will, before this week is over, but not right now. But you're allowed to impeach with a conviction. That has been a traditional, I have some serious questions about it, but a traditional method of impeachment. You can't do it in Hawaii, but I think they're more progressive than we are. But in any event, it's there, okay? Well, so you're going to impeach with a conviction. What we have is, we have Johnny over there. Johnny murders his wife. He doesn't like her. That's why people do things like that, okay? So he murders his wife. And as soon as he finishes shooting his wife, he grabs the phone and he calls the king's men. And he says, hey, you guys might be interested. I just murdered my wife. I'll be sitting here waiting for you. Here's the address at the home. The king's men come over, and there's dead wife, and there's Johnny. And Johnny says, I got to tell you, I had to do that. This woman was driving me crazy, okay? So they bring Johnny in. Johnny pleads guilty. Yeah, Judge, I murdered my wife. And he's sentenced, okay? And he tells the truth, right? And he goes to jail for murdering his wife. 15 years later, Johnny's out of jail, and now Johnny finds himself a witness in a case. He's going to be a witness. Can the other side impeach Johnny? Yes. What are they going to impeach him with? His conviction. His murder conviction, no less, right? We're going to bring out the fact that Johnny is a convicted murderer. By the way, you think that's pretty impactful? Oh, boy, that's big impact, right? Okay, by the way, does that have anything in the world to do with credibility? Veracity? Absolutely not. Johnny is the most honest murderer we've ever seen. He called the police, did everything, he pled guilty. Johnny's an honest murderer. But yet we're going to allow Johnny to be impeached on the basis of his conviction. There are some other less obvious examples, but it's not limited. Matter of fact, one of the big areas we're going to go into is, it does touch on veracity, okay? But it's that we don't prove that the witness is lying, but we do merely prove that the witness has a reason to color the truth, okay? And that's motivation impeachment. We'll talk about that tomorrow, probably. But anyway, so we've got motivation impeachment. So that definition is not a good one to start with, okay? Now, let me tell you what this is, how this started. I like to talk about this. Is it that instructive for you? No, not really. But anyway, for years, probably 15 years, one of the subjects which I spoke about was impeachment with inconsistent statement. That's what we're going to talk about today. You're going to enjoy that. I'm going to take you into a new world on that. And I've been talking about that for 15 years. I started the talk on that at the college's Advanced Cross program in St. Louis 1,000 years ago. And it's a subject I've always been interested in and like. And so I've always done it. I got a call, ironically enough, I got a call from the Florida Public defenders, okay? They used to get me down about every second, third year to do programs for them. And the fellow running the programs, Skip Babb, if he still is, I don't know, but Skip called me and said, Terry, would you come down and do our program? Well, it was in the middle of winter, and I'm up there where the snows are. Of course I'll come down. I'd be overjoyed to come down. So now we had to pick a topic, and I'd been coming down here for quite a number of years, and I'd covered, many topics. So we had to get a topic, and Skip said to me, he said, well, Terry, a couple of my people say you give a great talk on impeachment. I said, yes, indeed, impeachment with an inconsistent statement. I'd love to do it, and I think it's a good talk. He said, wonderful. You got 4.5 hours. Now, by the way, up until this year, I don't know if they changed it the year before or whatever, but up until that year, they always gave their speakers an hour. And I always told them, hey, an hour, I cannot introduce myself in an hour, and I need more time. So they usually give me a double or sometimes even a triple thing. But I always told them, I said, give the speakers a little more time to develop something. And I said, by the way, there's another benefit. You need fewer speakers. You can save travel funds and all the rest, okay? So Skip then told me, he said, well, Terry, we finally bought into your suggestion, and we're giving our speakers more time. You'll have 4.5 hours. I said, Skip, I think what you're doing is a great idea, but I have a major problem. My talk on impeachment inconsistent statement is about an 1.5 to 2 hour talk. I don't have 4.5 hours on that. And he said, well, you're just talking about that one form of impeachment? I said, yeah. He said, why don't you put together a talk on impeachment in general? And I stopped and I thought, and I, like many people, I can be very lazy if I want to be. And this was a sort of a challenge, but an interesting one. I love putting talks together. I had plenty of time. I think I had a 6-month gap in there. And I said, you know what? Fine, you got a deal. I will put together a talk. I'm going to tell you there's a funny little story in here too. And what the heck, we're relaxed, we're having fun here, we might as well. So, anyway, I said, well, I'll do that. And a couple days later, about 6 o'clock in the evening, that's when I love to work, is in the evening. People leave, nobody's running in and out, the phone's not ringing every 2 minutes. And I love to put together talks. And this one, I tell you, I was enthusiastic about putting it together. So I said, well, how would I put together this talk on impeachment, okay? So I decided the way to do it, and this was a good decision, was what I would do is get a list of all the ways one could impeach a witness. And then having gotten this list together, I would put the list of the methods in order. What order? Order of importance. The most important ones first, second, and so on, okay? And I thought, that's the way to do it. And then I would do the work on the individual ways, and now I have my macroscopic view of impeachment. So the very first night, with a measure of excitement, I tell you true, I started to prepare this list. And I said to myself, well, look at, your unillustrious career as a trial lawyer, MacCarthy, you must have impeached witnesses 24 different ways at least. So let's list those 24 different ways. And I started writing them out. Of course, I wrote down immediately impeachment with inconsistent statement, right? And I wrote down impeachment under 609 with a conviction. Those are obvious ones. And I started writing ways to impeach. And I got it up to 7 ways. And then I hit a brick wall. And then I'd think of one, and I'd say, wait a minute. You can impeach with an omission. We're going to talk about that today a little bit. But you can impeach with an omission. I'll put that. No, you don't put that down. That's not a separate way to impeach. That's part of impeachment with inconsistent statement is omission impeachment. So put it up there where it belongs, but it's not a separate way to itself, okay? So we did that one. Well, anyway, a few hours later, with abject frustration, I tell you, I left the office. I had prepared a list of 7, and that's as many as I could think of, ways to impeach a witness. So the next week, a few days, I talked to, Carol Brooke, who was my deputy director, one of the 3 brightest lawyers I've ever known in my life, and an incredible lady. And I talked to Carol, and I talked to a couple of my more senior trial lawyers, and they're good lawyers. And I talked to when I'd be on the phone talking to friends, Dale Cobb down in South Carolina, and these people. I'd say, by the way, I'm in this project, and I'm listing the ways to impeach a witness. Give me any ways you can think to impeach a witness, will you? And of course, this takes them on, right? And they'd say, oh yeah, Terry, well, you got X, or you got Y, or you got Z. It was already on my list as 7. So after a couple weeks of trying to think of more, I was stymied. And from brilliant people, I got absolutely no contributions. So I had 7. And then all of a sudden, one night I went to bed, woke up the next morning, and I had 2 more. So now I got it up to 9 ways to impeach a witness. I was happier, but still not. I thought there had to be a whole lot more than 9, okay? Now I tell you a funny story. This is not educational at all. You will learn nothing of it, but it's somewhat humorous, okay? I had the list of 9, and I went over to do a talk at one of the leading big silk stocking law firms in Chicago, located over in the Sears Tower. The senior litigation partner over there happens to be a dear friend of mine and a real fine guy. And he invited me over to have lunch with the 4 top litigation partners in this firm. And then in the afternoon, I was to talk to them on cross-examination, okay? And that was the game plan. So I went over and had lunch with these guys, delightful guys. And what do you suppose we talk about? We talk about trial advocacy, of course. And in the conversation, and I'm enjoying it, enjoying the lunch. And somebody brought up impeachment. It wasn't me, but somebody said, well, yeah, now what about this and impeachment? And all of a sudden, my eyes got big, and I said, well, guys, I said, you should know this, but that's my current love, impeachment. And that's what I'm working on, is impeachment. Really, Terry? Yeah, I'm working on that. And I've got a list, but I can only figure out 9 ways to impeach a witness. And as soon as I said it, the senior partner, the guy who was a buddy of mine, said, well, I know where you got your list of 9. And I was shocked, dumbfounded. I said, you do? How could you know? Because I didn't get, by the way, I went into obviously the evidence books and the trial ad books. There's nothing in there to help you. And I said, how could you know where I got my list of 9? I sat many of the evening preparing this list of 9. How could you know where the heck I got it? I said to him. He says, you got it from Irv Younger. And all of a sudden, this terrible thought came to my mind. It destroyed my day. And because I remembered that many years before that, I had heard a talk by Irv Younger, and the talk was entitled, The 9 Ways to Impeach a Witness. I was crestfallen. All this work I'd been doing, and here people will say, and rightfully say, he stole it from Irv. He plagiarized the whole damn thing, the 9 ways to impeach a witness. So, needless to say, I was destroyed. Really disappointed. He said to me, Terry, he said, I've got a copy of that talk. He said, I'll send it to you. I I said, thank you, But I was out of it by now, except that in the back of my mind, I remembered hearing the talk. And as I tell you, Irv Younger was as good a CLE speaker as I've ever heard. He even made this talk interesting. But I remember not being impressed with his talk on the 9 ways to impeach a witness. Even then, I remember not being impressed with the talk. I didn't know why I wasn't impressed, but I knew I wasn't that impressed with it, okay? Oh, I went up, did my thing. I'm at the office a few days later, and the mail comes in. And here's this envelope from the law firm. My God, I ripped it open, pulled out the article by Irv Younger, which I have, the 9 ways to impeach a witness. Oh, this article was going to destroy me forever, okay? And I grabbed it, and I started to read it. And I read his first of 9 ways to impeach a witness. And when I read it, I broke out laughing. And the pressure was off. I realized what I was doing was still going to be constructive. You know what his first way of impeaching a witness was? You impeach a witness on their oath. Their oath? What in the hell is that? Now, I've been teaching what I'm sharing with you now to lawyers for about 6, 7 years now, okay? And I have always asked groups of lawyers, I've had as many as 1,000 more in the room, but usually the crowd's around 200, 300 people, or 50 people, whatever it is. And I ask them, you're trial lawyers, yeah, all of you, anybody in this room ever impeached a witness on their oath? I have yet to get a hand raised. In other words, impeaching them on their oath is something an evidence teacher with a fertile imagination might think of, but it doesn't exist in real life. You don't impeach witnesses on their oath in real life, Irv. And so when I read that, being the first one, I was relieved, obviously, because this was, it wasn't going to be that good. And I read on, and it wasn't that good. As a matter of fact, truth be known, it was not good at all. Did he have some of my 9 ways? Of course he did. Impeachment, inconsistent statement, he had that. He had motivation impeachment. I don't remember what else he had in there, but he did have a few of the ways that were in my 9, okay? And then I read what he said about them and came to the conclusion that he was first and foremost an evidence teacher, and he didn't know what the hell he was talking about. He didn't understand them from a trial lawyer's perspective. So it was a horrible talk. Although, I got to tell you, I heard it as a younger lawyer and was somewhat impressed, though I wasn't totally impressed with it. One of the terrible things he did is Irv taught in New York, okay? And he was a judge for a period of time in New York. He was in the U.S. Attorney's Office in New York. New York has a goofy rule of impeachment that is totally unique to New York. If you ever go to New York to try a case, you will find that your latitude in impeachment is broadened. In New York, you're allowed to impeach with any bad, antisocial act that the witness has ever committed. Oh, my God. By the way, are you allowed to do that here in Florida? No. Any place else? No. As a matter of fact, the federal courts in New York have emphatically said that's New York's law. It doesn't apply when you're trying a federal case in New York, okay? But New York has that rule. And Irv, for some reason, was shocked because he was a good evidence teacher. He taught everybody that was the law of impeachment. It wasn't. It was unique to New York. So what could you do in New York if you're impeaching somebody? You could impeach the guy by showing that when he comes home every night, he belts his wife. Could you impeach with that in New York? Yeah. Or he comes in at night and he kicks the dog as he's coming in every night. He kicks the dog. You can impeach with that in New York, okay? Or, I don't know, maybe even extend to He doesn't mow his lawn at least once a week. I don't know. But this is the latitude given to you in New York, and Irv speaks of that, okay? So after reading his 9 ways of impeachment, I decided that I was in no way stealing. I had stole from him, but I was in no way stealing from him, and I could continue on, and I did continue on, and as a matter of fact, it became academic because I got it up to 13 ways to impeach a witness, okay? I've had it at 13 for several years, and I can't get any more, but if anybody can ever think of another way to impeach, share it with me. I'd be most appreciative. But I have figured out there are 13 ways to impeach a witness. Now, what did I do? I took these 13 ways, and this was a major contribution, I think, not only the list of 13, which is a nice list to have if you're going into trial, right? But I took them and I put them in order of importance. Well, what makes a method of impeachment important? 3 things make it important, right? What are they? Number 1, how often do you get to use it? In real life, in the life of a trial lawyer, how often do you get to use this method of impeachment, huh? That's very important. Number 2, impact. What's the impact level when you use it? Bang! What's the impact level? For most obviously, the biggest impact level would be impeachment under 609 with a conviction. You're a convicted felon. That's big impeachment. I mean, that turns the jury off in 2 seconds, right? So that's big impact level, right? And number 3, are there evidentiary restrictions on the use of this method? Because if there are evidentiary restrictions, that would go to lessen the score, if you see what I mean. In other words, the evidence people are going to jump in and say, well, this method of impeachment's there, but we're going to restrict you using it in certain ways. So if it's got evidentiary restrictions on it, it's not quite that impactful. So that's the thing. How often do you use it? What's its impact? And what restrictions? Are there restrictions on it? And so based upon that, those 3 criteria, I prepared a list of the 13 ways to impeach a witness. You guys, I'm going to give you this to take with you, okay? You're going to have to share it around, but in any way, here's my list of the 13 ways to impeach a witness. Now, by the way, I futz with this every once in a while, and I'm going to futz with it right now. Whoopsies. And I'm going to redraw a line. I've redrawn this line twice. But this is a work in progress, and I've redrawn the line twice, okay? There are, if you look at this list of 13, there's one up at the top, number 1. That's impeachment with inconsistent statements. That's not only number 1, but you see there's a line underneath there? And that line means that that's 1, and there's a gap. So maybe this shouldn't be 2 and 3. This maybe should be 4 and 5. In other words, there is no 2 and 3, okay? That means that there's a big gap in there, okay? And then I come down, and motivation comes in next. Truthfulness, impeachment comes in next. Conviction, 609, we've talked a little bit about. And this is one that people don't, trial lawyers do it, but people don't think about it as a separate one, but it is what the witness could have done but did not do. That's usually good stuff. The next one is capacity. There's one interesting issue in there under capacity. And then this one, the line, then there's a line. That line shouldn't be there. The line should be under 7 because contradictions really belongs up with that group. Contradictions belongs up with that group. So I will redraw the line under 7. And then there's the line again. And the line again means a little gap between that and the next group. And then we get a group of 4. Candor forces me to tell you these are not big ones. These are ones you could go an entire career as a trial lawyer and never use. Certainly never use effectively, okay? But they're there, so you should be aware of them. And we've got a writing used to refresh memory. Now, there was one case that I used that in beautifully. Oh, God, it was great. But you're not going to run into it often, okay? Admissions, yeah, if you're a civil trial lawyer, you'll use admissions once in a while. If you're a criminal defense lawyer, you'll probably never use it because for some ungodly reason, the law, making no sense to me, is to the effect that the king's men may not make admissions in behalf of the king. Oh, that's bullcrap. That goes to the divine right of kings, but we still linger on with that in the law. And then bad acts, prosecutors do use bad act impeachment, okay? They definitely, that's 404B. They use it. Criminal defense lawyers can use it. Anybody can use it. Civil lawyers can use it, but it's not used that often. The 11th one is habit. Habit. I am the only lawyer I ever known who's ever used habit in a courtroom. When did I use it? Years ago in a case. I was trying this case, looking at something, and I saw, I knew this habit was there. I didn't know much about it, but I knew it was there. So I read it, and I said, my God, I can use it to impeach this witness. And I did. I impeached him properly with habit, right? It came over as flat as anything you have ever seen. It, for all practical purposes, was useless, and the jury went on and convicted my guy, which is not unusual. Gave me another great opportunity to go up and get some appellate experience, of course. But in any event, you'll seldom, if ever, use habit. And then there's another line. And below that other line, there are 2 more, and the suggestion is that these 2 do not follow this sequence. Oh, they're not number 1, mind you, but they'd come in a lot higher in the sequence. They wouldn't be 12 and 13, except that the last 2 are methods of impeachment that apply only to one kind of witness, and that witness is the expert. These 2 only apply to expert witnesses. And the first one, and if I get a chance, because a lot of you are civil lawyers use this first one. They should use it. They don't. People don't understand it. You may impeach a witness with a learned treatise. And it's powerful stuff, and it's good stuff, and most people don't know how to do it. They don't know what it's all about. And then, of course, you can also impeach an expert witness with their qualifications. And I'm not talking about are they qualified to be an expert in the first instance, though that certainly can be an issue. But yeah, they're an expert. They can be an expert, right? So they can give opinion, but their qualifications are really susceptible. And many of these experts overstate those qualifications. They're ridiculous. So you can impeach them on that. There's some fun stuff you can do in there. So there's my list of the 13 ways one can impeach a witness, okay? Now, what are we going to do? We know that this is an order of importance. We are going to today talk only about impeachment with inconsistent statement, and then hopefully we'll finish that today, and tomorrow we'll talk about motivation and truthfulness impeachment, which unfortunately very few lawyers know much about, and judges tend to confuse these 2. Convictions, I don't know if we'll talk about or not, because conviction impeachment really applies only to and is of interest only to people in the criminal law field. So I don't know if we'll do that or not. What the witness could have, and we won't talk about. Capacity, maybe there's only one big issue there. Contradictions, Maybe. I may even cover that in the course of covering inconsistent statement impeachment today, because there's some parallels in there. And then, I don't know, maybe depending upon, I'm here for this week, of course, we may do learned treatises. I think that might be of some importance, okay? So, there's your list, okay? Now, we're going to talk about okay. Oopsies, here we go. I had more, yeah. We're going to talk about impeachment with inconsistent statements, okay? The most important one. Why is it the most important? Let's look at my 3 criteria. Surprisingly, if you thought about it and you asked trial lawyers this, I would bet you that 75% of the time, at least 75% of the time, a trial lawyer is impeaching a witness. They're doing it with an inconsistent statement. Okay, so that makes it very important. Well, what about its impact score? A good impact. Great? No. Nowhere near what conviction of a felony would be, but it's not a bad impact score, because you said something one time, you called it a green car, and now you're calling it a red car. So, there's a decent impact in there, okay? Well, what about restrictions on it? Yeah, unfortunately, this one has some restrictions. By the way, when I speak of restrictions, I'm talking about what the evidence people have put over this thing, right? And they have affected this one, and they have put a restriction in this one, okay? It's a restriction I don't like, but that they apparently like it, and so they put it in there, and we must be aware of it, because it is not what I like, it's the law, okay? And here's the problem with impeachment with inconsistent statement. Most trial lawyers, given the opportunity to impeach with an inconsistent statement, don't know what in the heck to do. What happens when I've got a witness on the stand, and there he is, I say to him, you saw a car? Yes. By the way, I use very simple examples, of course. You saw a car? Yes. Green? No, it was red. And I have a statement of the witness here. I don't need that. That's a terrible thing to have. I have a statement of the witness that says it was green. Can I impeach him with it? Of course, that's an inconsistent statement. You see it? Well, most trial lawyers, given that circumstance, and I was just in a program here this last weekend with very experienced trial lawyers, who were selected because of their skills to participate and do demos in this program. This situation arose there. And to a person, these trial lawyers didn't know what to do. They didn't know how to do their impeachment, okay? And what most trial lawyers do, young trial lawyers in particular, given this situation, soon as the witness says, no, it was red, they go like this. They hit themselves right in the forehead, and they say to themselves, oh, shite, okay? Oh, shite. They say to themselves, they don't say it out loud, and their feeling is this: I wish you wouldn't have said that. Why don't you just give me my green and let me move on? I'm trying to do this cross-examination. Indeed, I'm even trying to use the MacCarthy style and system across, and now you just rained on my parade, and this is terrible. But they know that there's something they can do, and that is, I can impeach you now with an inconsistent statement, and so they proceed to do the impeachment with an inconsistent statement. And it takes them all of 7 seconds to fulfill this impeachment, okay? Why? What do they do, and how do they do it? Here you go. Red. Oh, Okay. Well, you said something else to someone else sometime else, didn't you? Well, I think so. I don't know. Okay, go on. And that's what they do. 7-second impeachment with an inconsistent statement. Now, that's not what should happen. That's what happens in the courtrooms today. That's the way the law school students in these problems we have, that's about the way they do it, okay? Even the really talented ones. But that's not how you impeach with an inconsistent statement, good God. You want to watch a seasoned, experienced criminal defense lawyer in action in a criminal case, right? And I immediately think I saw two of them this weekend. Great. Albert Krieger over in Miami, and wonderful trial lawyer, okay? Great cross-examiner. And Dale Cobb is from Charleston, South Carolina. And Dale is a big man. He makes me look small, okay? And I think of those two because I was just doing a program with the two of them, okay? You watch either of those two given the same situation. You saw a car. Yes. Green. No, it was red, says the witness, okay? Watch them. You know what they do? They don't hit their head. They look up to their God and they say, oh, thank you, God. You know, I have a miserable case here, a lousy defendant over there, and this case is not going in very well. It's terrible. And I have not had the opportunity to do anything good since this case started. But God, thank you so much for this wonderful opportunity to really show some skill as a criminal defense lawyer. Thank you for this impeachment with inconsistent statement. I am ever in your debt. And that's what they say. And how long? 7 seconds? No. What about 7? No. What about, well, it depends how long they're going to take. What does it depend upon? Just how bad their case is. If the case is really bad, they take longer. If the case isn't quite that bad, they cut it down a little bit. But the worse the case, the longer they're going to take. Why? Because this is going to be the highlight of their case. They know they're going into an area where they're not going to get hurt, and all the while they're in this area, they will be looking good. And a witness will be looking horrible. So if it's a real bad case, let's milk this. Let's stay with this a while. Well, that's the way I want to teach you how to impeach with an inconsistent statement, the way these pros do it, okay? That's what we're going to do. How important is impeachment with an inconsistent statement? Well, I'll tell you how important it is. It's as if, now understand, you're not going to do this in an actual trial, but it's as if during the trial, as soon as the witness says, no, it was red, as if I now turn away from the witness and I turn to the jury and I say, you know, ladies, gentlemen of the jury, this is going to be a very important part of this trial because I am going to prove to you that this witness is at the very least mistaken, and more probably he is a liar. That's what I'm going to prove to you, and I'm about to do it right now. Do you suppose that would be rather impactful if you said that to the jury? Of course it would. But by the way, it also suggests to you that if you're going to impeach with an inconsistent statement, you better know how to do it, and you better do it right, and you better deliver, because that's where it's all at, okay? Now, impeachment with an inconsistent statement. And incidentally, if and when you guys want to take a break, you just tell me. I don't need breaks, but if you want one, just wiggle your finger or something and I'll give you a break, okay? Anytime you want, okay? Well, no, not in the middle of a sentence, but otherwise anytime you want. Okay. What I'm going to do for a little while is bore you. Now, I don't like to bore people, understand, but of necessity, I have to bore you for a little while, okay? What am I talking about? Well, we're going to talk about impeachment and inconsistent statement. I have to, first of all, give you a little bit of law. Law, that's not what you came here to do. You came here to learn to be trial lawyers. But I got to give you just a little bit of law, okay? Because you really need, that's one of the problems with impeachment, is there's a lot of law involved here, and it's all the law of evidence. And if there's any area that's screwed up, it's the law of evidence. So let's talk just a little bit about the law relating to impeachment and inconsistent statement. And then, on a high note, we will talk about how to do it. How do you impeach a witness with an inconsistent statement? How do you do it? Like a Dale Cobb and an Albert Krieger, for instance, okay? That's what we're going to do. Law. If you were to look this up, say, hey, this guy just spoke on, or he's going to speak on impeachment with inconsistent statement, how would you look it up? Or better yet, how would you find it in either an evidence book or in a trial ad book, okay? The topic you would look up is what? Impeachment with prior inconsistent statement, right? Isn't that the way that this issue appears in evidence books, trial ad books, impeachment with prior inconsistent statement? And then you would read, and if it's the evidence book, they'd give you a bunch of rules of evidence. We're going to talk about them, of course, and not necessarily even do a good job of always explaining them. And if it was a trial ad book, they'd give you a couple of little rules, but that's about it. They wouldn't give you, you're not going to find that list of 13 anyplace, at least not until somebody plagiarizes it, but you won't find that list of 13 anyplace, okay? But anyway, that's how you do it. So that's what I want to do then, is take those four terms, impeachment, prior, inconsistent statement, and talk about them ever so briefly, because I concede what I'm about to do will be a bit boring, okay? So let's take the first word, impeachment. Are there any issues? Yeah, under impeachment. There are, believe it or not, 3 issues under impeachment. 2 of them I'm going to cover for you now, and the third one I am going to mention to you, and it is by and away the most important of the 3 issues, but I'm not going to cover it right now. I'll cover it before the day is over, but not now. There's going to be a far more propitious, that's a good word, propitious time to do it. When? When I'm teaching you how to actually impeach, and we get to fishing rule number 2. Then we're going to talk about this third issue. I'll mention it now, but I'm going to explain it then, okay? What issues are there under impeachment, the term impeachment? Well, first of all, and this is sort of a stupid, the first 2 are somewhat, well, the first one's totally stupid, but I'll tell it to you because we want to know a little bit of evidence. When the drafters of the Federal Rules of Evidence, and by and large, I think they did a pretty good job. I really do. Well, did they make a few mistakes? Sure. That's human nature. Anybody would have done it, would have made a few mistakes, and they made a couple, but I think they did an excellent job drafting the Federal Rules of Evidence. When they drafted those Rules of Evidence, they put in a rule, 607. And 607 simply stated that you are allowed to impeach your own witness. Okay? They put that rule right in there. You're allowed to impeach your own. Now, you understand when the Federal Rules of Evidence came out in the early 70s sometime, but when they came out, that was the first major codification of the rules of evidence. And most of the states adopted those rules, okay? Well, you can impeach your own witness. And a lot of lawyers read that, and they said, oh my God, did you know we can impeach our own witness? That's something to remember. That's something we want to do. And I tell you in the next breath that that's stupid. Number one, what lawyer ever looks forward to impeaching their own witness? That's self-defeating, impeaching your own witness. It's stupid to impeach your own witness unless you really have to, and I can't think of too many times where you really want to impeach your witness, and there's other ways to go about it much better than impeaching the witness, okay? Well, by the way, they said, oh, this new rule, we could never impeach her. You could impeach your witness before this rule came out. You could impeach your witness back at common law. Believe it or not, there was no need for this rule at all. If anything, the rule has added confusion. Confusion to who? The trial judges. And I'll tell you in a moment how they've reacted to it. But it's added confusion to the trial bench, okay? But I told you, at common law, you could impeach your own witness. There was only one requirement, one thing you had to show to impeach your own witness. Anybody know what it was? Surprise. You had to show that you were surprised, okay? So you've got a witness on the stand, and you say to the witness, you know, well, this is direct examination, obviously. Impeaching your own witness, it has to be direct. So you say to your witness, you say, what did you see? And the witness says, I saw a car. And what color was, you notice this is not cross, you see, I'm asking questions. What color was the car? And the witness says, red. And you've got the witness's statement. And in the witness's statement, it says green. So you don't like that answer. So you want to impeach your own witness. There's other ways to do it short of impeachment I think are much better, but I'm not interested in that right now. So what did you do? You wanted to impeach him. Well, what did you have to do to impeach him? There's the judge sitting up there. So you'd say, and what color was the car? Smiling, right? And he'd say, red. And you go, ah! And the judge says, I got the notion, counsel. You're surprised. Yes, Judge, you see it? Ah! You're surprised. You show surprise on your face. We're trial lawyers. We know how to do this. Ah, Judge, you see it? Yeah, you're surprised, counsel. Go ahead, you can impeach him. And then you were allowed to impeach him. So we learned as trial lawyers, we learned how to show surprise. Ah! And there it was, okay? So we could always impeach our own witness. The rule wasn't necessary. As a matter of fact, and this is the ironic and funny thing, they wrote the rule in and said you could impeach, which is no difference, right? They didn't write in the requirement of surprise in the rule, but many federal judges, I don't know, I've never done the research to say most, but certainly many federal judges, and I think properly so, they'll let you impeach under the rule, okay, under Rule 607. They'll let you impeach, but they'll require you to do something before you can impeach under 607. What do you suppose they're going to require you to do? Show, surprise, okay? So there's no change. Impeaching your own witness is something you really don't want to normally do. We had a former Chief Justice, no less, of the United States Supreme Court in one of the, well, most absurd decisions I have ever read out of the court, for which I have great respect, by the way. It was a case, well, actually it was a case involving competency of counsel that got translated to becoming a case involving ethics, okay? And I'm trying to think of the name of the case, and it's Love was the one person, but who was the defendant? I'll think of it. but it raised the god-awful issue of perjury by a criminal defendant, okay? I can't think of the name of the case. It's on the bloody tip of my tongue, and I can't think of the name of it. But anyway, I'll think of it before the day. No, Withers? No, that's an old case. But anyway, yeah, you get old, your memory goes a little bit. But anyway, in this case, this decision, written by no less than the then Chief Justice of the United States Supreme Court, you know what he suggested to us, the criminal defense lawyers? That we impeach our own defendant. Oh my God. Any criminal defense lawyer who goes about impeaching their own defendant should be taken out, and I'm against the death penalty, but taken out and summarily executed themselves, okay? You don't impeach a criminal defendant in a trial, and that's what he suggested we do. I keep thinking of the name Love. Love was the dead guy in the case, and I can't think of the name of the defendant. But you'll find it under ethics, okay? But so impeachment doesn't make much sense, okay? Second issue, I have to go back in history to explain this issue. Normally I wouldn't take this much time, but we've got the luxury of time, and you might as well learn it, and you'll enjoy the history of it, I think. It's not going to be as informative as you might have hoped for, but you'll enjoy the history of it, I think, so I'm going to share it with you. Okay? I like sharing it. When I started practicing law, a long time ago, okay? And I was a young lawyer. I used to sit at counsel table with all the graybeards, the great and near great criminal defense lawyers, primarily of the Chicago bar, okay? And of course we tried cases. I tried them only in my criminal career, only in the federal courts. And in the federal courts, this was not unusual because there were usually many defendants in the federal court. Prosecutors love conspiracy charges, and for good reason, because once they throw in a conspiracy charge, they can then throw in the kitchen sink with it. They get in all sorts of otherwise inadmissible evidence, okay? Conspiracy has been called the darling of the prosecutor's nursery, and that's, if anything, an understatement, okay? So we'd always have a slew of defendants, almost all of them, their names ended in vowels, of course, but we'd have a slew of defendants, and I would represent usually one of the minor defendants in the case, okay, whose name would appear towards the end or the very end of the indictment list. At least in northern Illinois, the prosecutors normally list the defendants by order of importance, just as I list these by order of importance. And I'd sit there with these greats and near greats of the criminal bar, and this was the way I was to learn how to be a criminal defense lawyer. Well, here's an issue that came up fairly frequently, I might add, in cases that I tried as a young lawyer. What would happen is this. The FBI agents would go out and talk to Mr. Small here, okay? And they see him and they'd say, Smalley, I hate to tell you this, but you've got some real problems, my friend. We know you have not filed income tax returns for 4 years. That's a federal crime, Smalley, not filing income tax returns for 4 years, and we've got you nailed on that, okay? And so what we're going to do is we're going to get you indicted. They didn't even need an indictment for this one, but that's another story. An information would suffice. But we're going to get you indicted, and we're going to throw you in jail. And basically, when we throw you in jail, we're going to throw away the key because we know you're organized crime, okay? And we're going to do some terrible things to you. We'll probably end up taking your home. We'll put your wife out in the streets, earning keep through prostitution, and we'll sell your kids on the local market, okay? But here's that's what we're going to do to you. Are you ready, Smalley? Now, by the way, now they dropped the other shoe. We really aren't much after you. And by the way, that's the truth. We want Mr. Big over there. That's the guy we want, is Mr. Big. And we know you know and work for Mr. Big. So if you'll give us Mr. Big, we won't indict you. As a matter of fact, we'll even pay you while you work for us. You'll be one of what we call an informer, and you'll be a paid informer for us. We'll put you on our payroll, and we'll take great care of you while you're on our payroll, of course. Matter of fact, we'll do whatever else we can do for you that's good. Matter of fact, we'll even make you a federal magistrate judge, something like that, okay? But you've got to cooperate with us. You've got to give us Mr. Big over there. Now, there you go. There's your alternatives. Go to jail or, all these good things. Get on an extra payroll, everything else, okay? Well, in normal discourse in life, Small is going to say, well, oh, geez, yeah, okay, I'll go along with you guys, yeah. Well, tell us what you know about it. And so he gives them a rough idea about Mr. Big, and they say, okay, we're scheduling you for an appearance before the grand jury. And they take him down before a grand jury, they put him in, they swear him in, and he tells what he knows about Mr. Big. And he says, oh, yeah, Mr. Big, I know him, he's under oath. He says, I know Mr. Big, and I was there when he committed these 7 crimes. I saw him commit these 7 crimes, and I was there. And he gives them everything they want and then some to the grand jury, okay? That's step number 1. This happened, by the way, with some frequency, okay? 3 days before the case is set to go to trial, 3 days before, Smalley is walking down the street in the old neighborhood, of course, right? And 3 guys come up to him. I mean, these guys are, their knuckles drag on the ground when they walk, okay? They're all mouth breathers, right? Oh, God, they're something again. And they go up to him and they say, Smalley, you're a dummy, you know, and you're not going to say anything bad about Mr. Big, because if you say one word bad about Mr. Big, you know what's going to happen to you? And then they recite a litany of things. And guess what? Their litany of things is even worse than what the FBI told them, okay? Oh, my God, they threaten them beyond any way known to God or man. And what it is, in the words of the Godfather, it's an offer he can't refuse, okay? And they say, we're telling you one word against Big, and these terrible things are going to happen to you, your family, everybody else. Do you see it? Do you see? By the way, how would you like to be in his position right now? He's between a rock and a hard place. Got the FBI threatening him over here. He's got the mob threatening him over here. Holy smokes, what is he going to do? And many of the time, I'd end up representing these people. And it was no fun. I will tell you it was no fun. I did not give them, and I don't think I should have, advice as to which way they should go. But I had to leave them make this decision themselves, and it was a terrible decision to make, okay? So anyway, what would happen then is the trial would come. And now the prosecutor is all excited about this trial. he is trying Mr. Big. Oh, this is a big trial for the prosecutor. This is going to be another step towards the governorship of the state, right? And so he's trying this guy, and the moment of truth comes, and now he puts Small on the stand. Direct examination, okay? And he looks at him and he says, Small, tell us about the crimes committed by Mr. Big. And Small says, Mr. Who? Mr. Big, the crimes he committed. Hey, guys, I never heard of Mr. Big in my life. What do you mean you never heard of Mr. Big? I don't know who you're talking about, Big. Okay, now, the prosecutor is no dummy, and the prosecutor says, oh, you wise ass, excuse my expression, but we happen to have what? Grand jury testimony. Grand jury testimony of this guy. I'm going to impeach him with it. It's an inconsistent statement, right? Can I impeach him? Of course you can impeach him with it. Absolutely you can. So I'm going to impeach him. And then they would impeach him with his grand jury testimony, where he talked about all the crimes committed by Mr. Big, okay? And when they finished the impeachment, do you suppose the jury was ready to convict Mr. Big? Oh, absolutely. The jury believed what he told the grand jury and not what his current perjury is on the stand, okay? And they were ready to convict. Except they couldn't. They weren't allowed to convict. Comes as a shock to you. Why not? Because and this is the point I really wanted to make. I could have made it short of telling you the story, but the story adds a little bit to it, right? They wanted to convict, but the law, the common law of impeachment with inconsistent statement said you may impeach with an inconsistent statement, but what you're using to impeach with, in this case the grand jury testimony, that comes in, but it comes in for the limited purpose of impeachment. It only comes in to impeach. It does not come in as substantive evidence. You see it? So, what would happen? Those big shot lawyers would look at me and say, okay, kid, you get to make the motion. And they'd give me my moment in the sun, and I would stand before the federal judge, and I'd say, Your Honor, I now make a motion for judgment of acquittal. And the prosecutor would argue, well, wait a minute, no, we impeached him real well, we brought in everything he said to the grand jury. Yeah, that's true, but that comes in merely to impeach. It does not come in as substantive evidence. You have no substantive evidence, and therefore the case must be tossed. And the federal judges, and they're by and large a very good group of judges, the federal judges would say, yeah, you know what? We have to follow the law, and that's true. That didn't come in as substantive evidence. It came in merely to impeach, and you don't have any substantive evidence against this guy. And so they tossed the case. Well, that's not a good conclusion as far as federal prosecutors are concerned, okay? Now, by the way, did any other trial lawyers, except for federal prosecutors now, any other trial lawyers, civil lawyers, criminal defense lawyers, prosecutors in the state court, whoever, did any of them concern themselves with this issue? Not really. Not a single one concerned themselves. Why? They didn't care. They didn't run into the issue. And a trial lawyer, a real trial lawyer in most instances, doesn't care how something comes in as long as it comes in, as long as the jury hears it. And going back to our case, if that jury went out and deliberated, would they convict Mr. Big? Absolutely, they'd convict him in 2 seconds, okay? But they don't get the opportunity. So federal prosecutors did not like the law. They didn't like this restriction on impeachment with inconsistent statement. Comes in only to impeach, not as substantive evidence. You see it? So, who's got more clout than federal prosecutors? Nobody. Huh? And their clout started actually before the federal rules of evidence came down. There was a goofy case, oh God knows. Don't read it, because if you read it, you'll never understand it. I don't think the court that wrote it understood it. It's called California versus Green, okay? I can tell you California versus Green was decided in 1970, okay? That's right before the rules were amended. And California versus Green is the first major breakthrough in the area. What breakthrough? A breakthrough that say, no, we're going to allow it to come in as substantive evidence under certain circumstances. By the way, the court writing California versus Green knew they were changing trial advocacy drastically, but didn't understand the issues that well. And they knew what they wanted to do, but they didn't do it well. Let me put it that way. And we got a convoluted case that doesn't make a great deal of sense. Now, when the drafters of the Federal Rules of Evidence a few years later got hold of it, and they were implored by the federal prosecutors who said, and by the way, did the federal prosecutors have a legitimate complaint? Yeah, I think they had a damn legitimate complaint here. And I think that they properly lobbied to get it changed. And if I hate to admit this, but if I were on the Federal Rules of Evidence Board, I think I would have agreed with them. This was but another evidentiary restriction that didn't make a lot of sense, you see. So if it's an evidentiary restriction, it doesn't make much sense. Clean it up, make it the way it should be. And I think, so frankly, I think the change was a good one. And that's a shock coming from me, criminal defense lawyer, okay? But they changed it. And when they changed it, they realized they were fighting with history here. They were fighting with what we had brought over from jolly old England, of course. And so they said, we're going to change it, but we can't just throw it out and say that every time you impeach with an inconsistent statement comes in as substantive evidence. We don't want to go that far yet, you see, because there's a history for this thing, right? And that history must have some basis in common sense, so we're not going to throw it all out. So they came up with a rule. And the rule, which is misunderstood by most people, by the way, but the rule simply stated that sometimes when you impeach with inconsistent statements, it's going to come in as substantive evidence. And other times, it's going to come in merely to impeach. Okay, well, how did they draw this distinction? Okay, and by the way, you see that this is going to be a restriction now. We talked about having restrictions. Here's a restriction. Sometimes it's going to come in merely to impeach and not as substantive evidence. That's a restriction. Okay, well, how did they break it down? Well, how they broke it down, I'll tell you, but most people writing about this subject or talking about it screw it all up. They put in one requirement. And I'm going to simplify this for both of you guys for forever, okay? Here it is. If the statement that you've got there, if that statement was under oath, okay, under oath, then it comes in as substantive evidence. So you got a deposition, it comes in as substantive evidence. Okay, grand jury testimony, substantive evidence. If the statement you're using to impeach was under oath, it comes in as substantive evidence. Now, you will find many trial ad teachers included teaching this somewhat incorrectly. They say it has to have two requirements. Now, by the way, you know we'd never use two. One, okay, or then three, but never two. Anyway, they say it must be under oath and subject to cross-examination. That's what most people teach. Guess what? That's not accurate. The rule talks about being subject to cross-examination, but they're not referring to the inconsistent statement being subject to cross-examination. And good God, how do we know this? We know it because we know the origins of the rule. We know what it was intended to alleviate. And you know, and I know, and stop and think about this for a moment, when a person appears before a grand jury, is that ever subject to cross-examination? No, of course not. And that was the intent of the rule, was the cross-examination situation, the very one I gave you. So that's not subject to cross-examination, yet it comes in as substantive evidence. Why? It was under oath. When they talk about cross-examination, evidence professors should look at this, by the way. They're talking about the right to cross-examine the witness on the stand. Now, not the original statement being subject to cross-examination. So that makes it simple for us. Under oath, comes in as substantive evidence. Not under oath, it comes in only to impeach. So you're trying a case. You're a civil lawyer, or better yet, you're a criminal defense lawyer. You got a witness on the stand, okay? And you impeach him. And what you're impeaching him with was under oath. Maybe it's grand jury testimony. Let's leave it in the criminal context, which makes me more at home, okay? So what you're going to impeach him with was grand jury testimony, okay? And I'm going to impeach him with that grand jury testimony. And I finished the impeachment. We have to show you how to impeach, but in a moment. But I finished that impeachment. Now, what do I do when I finish the impeachment? I look up at His Honor, and I say, Your Honor, would you please instruct the jury that what I have just used to impeach this witness comes in as not merely to impeach, but as substantive evidence? Well, you just contradicted yourself, MacCarthy. You told us earlier that trial lawyers don't care how it comes in as long as the jury hears it, because the jury doesn't make that distinction. Oh, this comes in as substantive evidence. This only comes in. The jury can't do that. They don't know how to do that. They're not facile enough to be able to do that distinction, okay? So as trial lawyers, we don't much give a toot how it comes in as long as it comes in. And you've told us that, but now you're telling us to get an instruction that it comes in as substantive evidence. I am. Why? You're entitled to it. You might as well ask for it. And what's the judge going to do if he gives the instruction? He's going to loop into the jury the good thing. And he's going to look over at the jury. He's going to say, ladies and gentlemen of the jury, what you have just heard, blah, 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 comes in not merely to impeach this witness, but as substantive evidence. And you may consider it as substantive evidence in your deliberation. So that's not bad. This was something good, and he's going to loop it into the jury. What's the other possibility? The other possibility is he will not give that instruction. I'm not instructing that way. So what happens then? You've got another harmless error argument when you get up to the Court of Appeals, okay? And you can argue he should have given the instruction. You're not going to get real far with it, I will tell you, but at least you got another harmless error. So if you got the opportunity, avail yourself of it and take it, okay? Yeah, I'm thinking, boy, MacCarthy. Well, you know why? I'm going slow. But this is, to me, a unique opportunity to expound on this. When I give talks, I always have tremendous time restrictions, and I can't develop some of these issues the way I think they should be developed. You know, all the little stories and stuff that I think, by the way, you'll remember that. You'll remember that issue because you'll remember the circumstance under which it arose, and that's the way to learn. Okay, there is still but a third issue under the heading of impeachment, okay? And the third issue is, without question, the most important of all the issues. And the third issue also brings into play a restriction on impeachment with inconsistent statement. Now, we already have one restriction. Some of it comes in only to impeach. That's a restriction, right? But now we're going to see an even bigger restriction come into play. Restrictions from who? Evidence people are putting these restrictions on us. So anyway, here's the other restriction. And this restriction, by the way, I think is, for the most part, stupid. But that's my opinion, and I guess I'm in a minority in there because nobody seems to be even thinking about changing. The issue is this, big issue. When you impeach with an inconsistent statement, okay, sometimes that impeachment will be, oh God, you don't want to hear these terms, but I've got to use them. Sometimes that impeachment will be collateral. Do you remember this? We took evidence, right? You remember collateral, non-collateral? You never fully understood it when you took evidence. When you finish with me, you will understand it. You will never forget it because I'm about to. Am I going to explain it right now? No. I'm going to explain it when we get to the second fishing rule. And then I will explain it for you so that you could never forget it. You will possess it and one other important thing at the same time, okay? But right now, for purposes of right now, you should know that it's there. So that sometimes when we're impeaching with an inconsistent statement, that impeachment will be only collateral, okay? Well, what does that mean? We can do that here for now. That means that if it's collateral, then the witness can, if the witness denies it, you're stuck with the witness's answer. You can't do anything with it. If it's not collateral, then you can bring in what are the evidence teachers? Extrinsic evidence. That's what they call it. You can bring in the extrinsic evidence to prove it. So, very simply, you saw a car. Yes. Green. No, counsel, it was red. And I have a statement of yours that says green car. Now, and I say to you, you have to learn how to do it, and you will momentarily, not momentarily, you learn it tomorrow now, but I want to use this statement now to show that you said green car. So that I finally say, well, let's jump ahead and do it the way most mopes do it, okay? This is not the proper way. Well, you said something else earlier that was different. You said it was a green car in your statement to the police officer. And the witness looks at you and says, and you got the statement of the police officer, right? In the statement he said it was a green car, right? You got it there. And you told the police officer it was a green car. And he says, no, I never told the police officer that. Well, can you bring in that? You'd like to bring in that statement, wouldn't you? But if it's collateral, you can't. So he's going to get away with a lie. So he's getting away with two lies. Okay, that's why I don't like that rule. That collateral rule is stupid. Well, why do they have the collateral rule? They have it to speed up the trial. They have it so the trial can proceed with dispatch. That they don't want to go into trivial issues. Well, my arse, trivial issues. If a witness is lying on the stand, God darn it, that's not a trivial issue. And give us the time, I hate to say this, to prove that the witness is lying. So you see, I don't agree with the rule, okay? But there it is. I will explain it to you so that you will always know collateral, non-collateral, okay? Now, we can do the second one because the second one's not going to take much time, and then I can get you guys out of here as ordained around 1 o'clock, okay? The second word that you find when you go into this is impeachment with prior, okay? Prior, the word prior. Now, I'm going to tell you bluntly, any suggestions what we could do with that word prior? Nope, no suggestions. Okay, I'm going to tell you what they are. We are going to get rid of that word. we're going to get rid of that word for 3 reasons. We're going to get rid of that word. Remember that, 3 reasons, okay? Let me give you the first 2 and see if you can come up with the third one. Is that fair enough? Okay. Rule number 1, or reason number 1 why we're going to get rid of the term prior is it violates my Rule 11. Rule 11, MacCarthy's Rule 11 of trial advocacy is simply stated, you speak in a courtroom the way you speak in a bar. A nice bar, obviously, but you speak in a bar, okay? Prior is not a term we use in the bar. I don't go up to you in a bar and say, well, what was your drink prior to this one? You know, that's stupid. That doesn't pass our litmus test, obviously. So that's a stupid word. Prior's a lousy word. We want to get rid of all the priors. So we're not going to allow it to exist here, okay? So that's the first reason. It violates Rule 11. The second reason we're going to get rid of prior is an even more, well, more obvious reason, if you will. It is a stupid, redundant, and totally unnecessary term, isn't it? Can you people think of a statement I am going to use to impeach a witness, right, that was not made before the impeachment? Of course you can't. It's metaphysically impossible to think of a statement that was not made before, okay? So, any and all statements that we use to impeach were made before. None of them are going to be made, after. So prior is a stupid word. Every statement we're going to use of necessity was made before. So why use a stupid word like prior unless we want to be lawyers and use that god-awful word? So we're going to get rid of the term prior. Now, there is still a third reason why we're going to get rid of the term prior. And let's see, short notice, I know, but if you can come up with the third reason we're going to get rid of prior. I'm looking for a brilliant observation here. Simple but brilliant. What's the third reason? Pardon me?
The rule of 3.
Yes, but explain that just a bit. Do you understand what you're saying? I think you do. By God, I'm going to give you credit for that. I like you. I'm going to give you credit for that, okay? The rule of 3. Absolutely. Why? Because if we get rid of that stupid word prior, how many terms do we have left? 3. Impeachment, inconsistent statement. And we are where we want to be, but we have to dump prior to get there. Thank you for your good thinking, okay? The next one would take over 7 minutes. It's inconsistent. Your pleasure here. By the way, when this is all over, I don't know what your 2 plans are, but if you'd like, I will take you to lunch. I don't have a car, but I will still take you to lunch, okay? But anyway, here we go. Do you want me to do this inconsistent for you or not?
Let's finish the rule. Let's finish the 3. Yeah.
Okay.
Let's do it.
Okay. Inconsistent. Well, this one's going to take but a few minutes. Not that long, but a few minutes, okay? We're on a roll anyway, so let's do it, okay? Inconsistent. To do it, to impeach with an inconsistent statement, it has to be inconsistent. Well, what's inconsistent under the rule, under the evidentiary interpretation? Well, not shockingly or surprisingly, there are 3 things that are in. See, the rule of 3 is amazing. 3 things that are inconsistent. What's the most obvious one? The one that 85% of the time you're impeaching with an inconsistent statement, this will be it. You're going to be impeaching with something which is contrary. Contrary, okay? By the way, I should have given you this at the beginning, but I didn't want you looking ahead. You got to get a copy of them. This is what I'm using right now to talk from. I mean, this is the outline, okay? See, impeachment, prior, inconsistent statement, and then we're going to go down into the 6 fishing rules. This is the fun part of this whole thing. This is how we do it, okay? I'm going to give you that. But anyway, here you go. Inconsistent. The first one is the one you, 85% of the time. What is it? Something that's contrary. For instance, you saw a car. Yeah, green. No, counsel, it was red. Red and green are contrary, right? So can I impeach with the contrary? Yes, that's the most obvious. That's the one you're going to have most of the time when you're impeaching with an inconsistent statement. A contrary statement, okay? We got that? Okay. Second one, and this is, ironically, the demos I saw day before yesterday, the demos, the lawyers did a pretty good job on this one. But the second thing you're allowed to impeach on is omissions. Omissions. You can impeach on an omission, but you got to know just a little bit about that. What are we talking about when we talk about omissions? And I'll tell you what it is. Something is not in the statement, okay? In other words, I have your statement here, and now you take the stand. This is the way it comes up. Now you take the stand and you testify to something that's not in your statement. And now this is very important. Well, this is very important. That's redundant. The thing that is not in your statement that you're testifying now to, if it's important, if it's not important, it doesn't matter. But if it's important, then I can impeach you with the omission. If the omission was important, you follow that? I'm simplifying this for you, but that's the rule, okay? If the statement was important, then you can impeach. Give us an example, MacCarthy, because then we'll better understand this. By the way, I am watching, and I will make later reference to this, okay? But I just did a horrible thing for a trial lawyer to do. And I was just at a big program about a month ago, when I saw 2 really talented trial lawyers, national teachers of trial advocacy, advocate doing what I just did now, which is horrible and stupid. What did I just do now? I passed over a document. And that's the dumbest thing you can do. We're going to talk about this later, but you don't. Well, they call it publish. Publish. It means show it to the jury, God darn it. But you publish it to the jury. Sure. Well, I just published something to you. I showed it to you, right? But that is the dumbest thing you can do when you're still doing your cross-examination. Why is it the dumbest thing? Because they're going to start looking at it as soon as you give it to them. And when they're looking at it, they're not listening to what you're doing in your cross. So wait. This is just a side trial ad thing. So wait. Publish it if you like that word. I don't. Show it. Your Honor, may I show this to the jury? Oh, no, most lawyers. Your Honor, may I now publish this to the jury? Oh, bullshit, publish. But may I show it to the jury? Yes. That's fine. But wait until you're finished and then show it to the jury. Why? Then the jury is going to read it when your opponent is doing redirect or whatever the hell it is, or putting their next witness on the stand or whatever. Now they can have a good go at it and read the bejesus out of it. I hope they read it. Give them some good pictures to look at, whatever the hell it is, but not when you're doing it. I got diverted, but it's a good trial ad tip for you to know. Okay, now, omission. I was going to explain to you omission, and here you go. Example comes up with some frequency in the criminal law area, not where I practice in the federal court, but this is a state court situation where we're talking about garden variety crimes, okay? What happens is Officer Jones is out on patrol one night, and he sees a car. And the car is what they call a lowrider with dark windows, and as much as he can see in the car, the people in the car are people of color, okay? Tough neighborhood, decides they must be up to no good. So they pull the car, Jones and his partner, pull the car over to the side of the road. Well, now they've got a little minor problem, and that is, for what reason did they pull the car over? So they give themselves a reason. And the officer with the larger boot kicks in the rear parking light there, okay? And they pull the car over and say, your rear parking light is broken. Of course it's broken. The glass is still right there when they kicked it out, but they've got the reason to justify. Now, I'm not saying all police officers do this all the time, but it does happen, and I'm just giving you a scenario of crime on the streets. They walk up to the car, the driver puts the window down, and they ask him, well, who are you? What is it? Well, and he gives his name. And is this your car? No, actually it's not. It's my girlfriend's car. And he's got the registration and everything, and she's allowed me to use it, okay? And there are 3 men in the car. The driver, somebody in the passenger seat, and one guy in the back seat, okay? And in the back seat, at the foot of the one guy in the back seat, there is a bag, a big bag, and in the bag is white powder, okay? Police officer spots the white powder, takes his finger, sticks it in, tastes it, and says, oh my God, I think that's an illegal drug. Not scientifically, but based upon his knowledge. He's right, by the way. So what does he do? He arrests the driver of the car, okay? And charges him with possession of this narcotic substance or whatever it is, okay? And he charges him, arrests him for it, and he's charged with it, okay? Now we go to 2 days before the case is scheduled to go to trial. And the young assistant district attorney, and they're grossly overworked, like everybody else is, the public defenders, and frankly the police officers as well. They're all overworked in our criminal justice system, maybe because we have too many crimes, by the way, but in any event, they're all overworked, and the prosecutor says, okay, Smith, what do you have here? And Smith says, oh, I got a great bust, counselor. Wait till you hear this one. This is a good one. You're going to like it. And he tells him what happened. And the young district attorney says, wait, hold it, Smith. Smith, God darn it. We don't have a case. Smith says, well, what do you mean we don't have a case? I don't have a case here, Smith. You're an idiot. How can I prove that this was the driver's, let's make it marijuana for want of a name, the driver's marijuana? I can't prove it. I mean, this could have been, well, number one, the guy in the back seat had it with him. It could have been his marijuana. Maybe the other guy in the front seat owned it. Maybe the owner of the car, the girlfriend, maybe this was hers and she left it in the car. I can't prove it was the driver's marijuana. I don't have a case at all, and I'm going to dismiss the case. Young prosecutor, right? Going to do the right thing. All of a sudden, Smith, I think that's what I call the officer. I changed their names, but bear with me. Smith says, well, hold it, counselor, hold it. I see where you're coming from now. I understand where you're coming from. I see the mistake. But really, you can go to trial with this. No problem at all. Well, how do I go to trial with this? Well, you put me on in direct. You asked me the question, what did the driver of the car say when I picked up the bag of marijuana? District attorney guy says, wait a minute, what the hell are you talking about? I've got your official police statement here. There it is. There's no mention of him saying anything when you picked up the marijuana. And he says, that was Charlie Rose that stuck his head in there. But anyway, he said, there's no mention of it in your official police report. He said, no, counselor, I know there's no mention in my official police report, but I'll tell you what. You just asked me. Okay, well, if I ask you, what's your answer going to be? My answer is going to be, he said, hey, watch out or you'll spill my marijuana. Now, do you have a case, counselor? Yeah, under those circumstances, I'd have a case. So the case goes to trial, puts him on the stand, and did he say anything? Direct examination. Did he say anything? Come in, Charlie. So we're just about finished.
Okay.
Did he say anything when you picked up the marijuana? And he said, yeah. He said, hey, watch out or you'll spill my marijuana. Okay, now, there's the circumstance. You see it? Do we have an omission under those circumstances? Of course we do. Of course we do. Number one, it's not in the official police report. And more importantly, number two, it's important. Important, good God, it's the entire case, okay? So there's the omission. Now, the problem with it, from a trial lawyer's perspective, the problem with it is there's not a lot you can do with it. You can do it, understand, but it's not a powerful thing to do. How do I know? I've done it a lot. I've watched others do it, and it's not powerful. The one thing it does bring into play, contrary to what I taught you, the basics of cross-examination, there's a couple of times we violate some of the essential rules. This would be one of them, where you would literally walk over. The most effective way to do this, and you'd walk over to the police officer when you're doing this, and you build up the police report and all of that. And I'll show you how to do that tomorrow, but you build up the police report and then you hand it to them, and I'll show you how to hand stuff to people too. But you're going to go over with the police report and say, now, Officer Smith, would you please read to the ladies and gentlemen of the jury what your official police report says about the statement the driver made when you picked up the bag of marijuana. Would you please read it to us? And of course, what's he going to do? He's going to have to say, well, it's not in there. Yeah, is it powerful? No, but it's something, and it is a method. There's a third one, and then we'll shut down here, but there's a third thing that qualifies, and that is, and I'm shocked at the number of police officers, lawyers, that don't know this, but when you've got a witness on the stand, and you put it, who's your witness? Your witness is Cato Kalin. Huh? Or, hell, Cato Kalin, how about a former Attorney General of the United States, Gonzalez? You've got either one of those two on the stand, and you ask them, you saw a car. You don't ask them, you tell them, you saw a car. And what's the response from Cato Kalin? I don't know, I don't remember. And what's the response from the former Attorney General? I don't recall. 90-some times he said, I don't recall, okay? Cato Kalin was just full of I don't remembers. Okay, what about those witnesses, those people that say, I don't recall, I don't remember? Can we impeach them? Yes, we can. Most lawyers don't know that. They can be impeached. But now, having told you that you're allowed to impeach them, in the next breath, I'm going to tell you that you probably will not impeach them. There are 3 ways to punish the puppy on the stand. One, we talked about just simply tweaking him, hitting him in the nose with newspaper, tweaking him. The second way, you get to make a fist, put it here. You can't bring it back. You equal your body, and you get to hit them with a short punch. If you're Joe Louis, you can do something with that. But anyway, you hit them with a short punch. That's the second way. And the third way is you get to go back 5 steps with a Louisville Slugger bat, run at him, and belt the puppy in the head. Now, the second way, the first way we've gone into. The second way is, oh God, you don't want to hear this, but I got to mention it now, refreshing recollection. Remember that? You learned it in evidence class. You learned it with its twin sister. Past recollection recorded. You didn't understand either of them. You got through enough to pass the exam, and that was it. That was as far as you would go, right? And you hated those 2. And why did you hate them? Because they made no sense at all. Why did they make no sense? Because they're creatures of evidence teachers, and they made no sense whatsoever, okay? But you got to know something about them, and we'll get to that in a moment. So that's refreshing recollection, and impeachment is the 5 steps in the Louisville Slugger bat. That's what we're going to do tomorrow, is the real impeachment. But let me just take a moment of time, and then I can quit the punch, the refreshing recollection. You're trial lawyers. You're going to be trial lawyers. Now you've got to know something about refreshing recollection, even though you hate it and even though it doesn't make much sense. And frankly, it doesn't, what the way they do it. The funniest scene, and I'm going to see, maybe Professor Rose can find this for me. The funniest scene you ever watch, I think it's befitting the 3 Stooges, okay, is the O.J. Simpson case. And the witness was who other than Cato Kalin, the Wisconsin Flash, okay? Marcia Clark, oh God, not a good trial lawyer. Marcia Clark put him on a direct. It was a miserable direct. Oh, it was miserable direct. Now, by the way, would this have been the one time, maybe, we talked about it earlier just in passing, but where the defense would say, we have no questions of this witness. The one time you'd say, I'm not going to cross-examine. Yeah, it would have been. Although there was another witness who was even better on this, and they didn't. The poor soul that took the luggage at the airport, but that's another story. But now, no, the defense decides to cross-examine. We had a lawyer in here, a student in here the other day, and I asked her, she's from Los Angeles. I said, what are you going to do when you grow up? And she says, I'm going to go walk with Shapiro. I got a little scared when I heard that. But anyway, Shapiro is the cross-examiner of Cato Kalin. And as bad as the direct was, I thought I could seldom see anything worse. The cross beat it, okay? And there's a scene in there that I want to get. I want this, because this is right out of the 3 Stooges, where Shapiro's got him on the stand, and I do remember what it was, a little bit about what it was about, but I'm not going to be word for word, believe me. But Shapiro wanted to show that when Cato Kalin walked out of his little house back there, that when he walked out, he saw the white Bronco parked in front. That's what he wanted. Did he have reason to get that? Sure. What did he have? He had Cato Kalin's grand jury testimony. It said, when I walked out, I saw the white Bronco. But, of course, he had no concept of cross-examination in the world, and he was struggling along, asking questions, screwing up, and he got to the moment of truth, and he said to Cato Kalin, well, when you walked outside and you looked around outside, what did you see? By the way, That's not cross-examination, that's direct exam, but that's all right. What did you see? And guess what the response was? I don't know, I don't remember, okay? So now you get the I don't know, I don't remember one. This is cross-examination, of course. So you want to get the white Bronco. It was important to him to bring out the white Bronco. So he starts to try. Well, didn't you tell the grand jury? And she jumps up and objects. And she's right on the law. And Judge Ito is right on his ruling, sustained, okay? And so he tries again another way, and he tries again another way. And this goes on, it's 5, 6, 7, 8 minutes, I don't know. And if we had the benefit of these little, you know in the comic strips how they have the little circles going up, and that's what he's saying, but he's not saying it out loud. He's saying it only to himself. Remember those things? Okay, if we had those, here's Shapiro up there, and he's saying this only to himself, and he's saying, good God, I remember in law school, I learned that there's something I can do right now with this witness. I have the grand jury testimony. Huh? I got that. I can do something. What in the hell is it? And how do I do it? He's saying to himself, right? And he struggles. Every time he tries to do something, Marcia Clark objects. Ito sustains the objection. Finally, Ito knows that he's got to move this thing on. So Ito looks down at him and he says, Mr. Shapiro, are you trying to refresh recollection? And Shapiro, bubbles go up again. And he says, my God, that's it. I remember learning that in law school. Yes, Your Honor, I want to refresh recollection. Well, go ahead with it. And he proceeds to go ahead with it, okay? He screws it up completely in how he does it. And she objects again. Ito now overrules the objection and lets him do it the wrong way, okay? But when you refresh recollection, tomorrow we're going to talk about how you show the witness a document, Trial Advocacy 101. But right for purposes of right now, I've got a document that I want to refresh recollection with, and here it is, okay? Forgetting the preliminaries, that's tomorrow. But all you do is you walk up to you get permission usually from the judge if you must get it, but you walk up to the witness. Don't identify the damn document. Everybody wants to identify it. You've got the document. You walk up to the witness. You hand it to the witness. And by the way, this is cross-examination, no questions. And you say, you know what that is. Witness looks at it. Yeah. Now, would you read to yourself? And you've got it highlighted, with a highlighter, the 1 line, 2 lines, 3 lines, whatever the hell it is. I saw a white Bronco was out there. You got it highlighted. And you say, would you read that to yourself? Please don't read it out loud. Just read it to yourself. They read it to themselves. And then when they finish reading, you take the document back from them. And now you do the same, statement, in my opinion, and statement. Now, you saw, and by the way, you see, if you used the correct cross-examination technique to start with, you probably wouldn't have had this problem. Yeah, and you looked around. Yeah, you saw something. Yeah, a car. Yes, in front of the house. Yes, a Bronco. Yeah, a white Bronco. You see, that's the way, and you would have got it. But no, you're not going to get it the other way all the time. An idiot like that. But now you take it back, and now you just say, well, you say it my way, you saw a white Bronco. And he shouldn't give you a white Bronco because he's just read white Bronco. Well, what happens if he doesn't? Then get out the Louisville Slugger bat and impeach the dumb SOB, okay? By the way, and this last thing, then we're close. During that stage, I said the Three Stooges, it was incredible. You know what he kept referring to the grand jury testimony as? In that case, nobody ever had a copy of what anybody else had. And Marcia Clark said, what are you reading from? Or something like that, okay? And he said, he called it, and he did this at least 3 or 4 times. He said, it's in your murder book. Your murder book, mind you. Come on. This is the stupidest thing I've ever seen. But that's refreshing recollection. You may refresh recollection, or you may impeach if you get an answer I don't know. I don't remember. You two are beautiful. Thank you so much for being here with me, okay? Thank you. You can turn that off, Charlie.